Yeah, and you're never really going to take the people are never going to give up their right to select their judges, probably. But until businesses, like, it's like until you get screwed by a judge, you don't realize how important it is.
Yeah.
It's one of those things. Like, I'm always like, I don't know why you spend so much money on an assembly person. Judge is more important.
Yeah.
I mean, the assembly people don't get anything actually done.
So they
But
should
a
probably
judge
be
does.
appointed, huh?
Yeah, I mean, I think what you could
In
do,
most cases.
what you could maybe get away with is give a legitimate recall power, or give something to the people that is a legitimate populist check. But some of them do hybrid systems where you have an appointment and then an election. Kind of what we have with the Court of Appeal. Sandoval's appointed, that's late.
Yeah.
But the way it went on the ballot, which is approved, is that they're on the
Approve those
ballot. They
people.
have to get elected from here on out.
Yeah. That's probably a
And
good
so,
way to do it.
At least you get maybe some better quality, but
Yeah.
you're still not getting good lawyers that are going to go on the bench.
Yeah.
It's a bigger problem. That's the problem.
Well, anyways, what's the?
So I wanted
there must be
to-
some kind of
yeah.
emergency brewing
Well,
of
it's
some
not-
kind.
It's just timely. I wanted to talk to you one-on-one about the Las Vegas Sands. I know Brent and Katie talked to you about it a number of weeks back.
Oh, the attorney-client
it's
or
privilege
the
issue.
463-120 thing.
I don't know if the governor spoke to you about it, or Mike. Allegedly, they're in the loop. But, that's part of why I just want to talk to you one-on-one. There are so many cooks in the kitchen. Obviously, the Las Vegas Sands have requested support.
Yep.
And I think we've reviewed their broad request, and most of it is absolutely not possible or appropriate.
Right.
I think their biggest thing that they want is this investigative hook, where if this is a joint investigation, then everything is covered, and as far as I understand, there's no way that's going to happen. That's sort of off the table. So is that correct?
Well,
Or at least it's something you guys are never going to represent.
well, I'll give you my understanding of the whole situation, because I'm not 100% familiar with the nuances of the federal law in regards to the collaborative or joint investigation or separate paths or whatever. But Jacobs and Adelson are in this litigation. There's discovery requests bouncing back and forth, which is routine.
Right.
And our policy forever has always been we don't interfere. If we do get very concerned that there's going to be some encroachment or impingement of 463-120, the confidence statute, then we think about it.
Right.
In terms of this particular case, Bryn and Caton came, and my staff has also been reviewing the requests, and there were, like 7, I think.
They're coming directly to you guys too?
Bryn?
No,
or
no.
Sands?
The same.
They came to us directly initially,
Okay.
and we ended up telling Ira Ralphison, the GC. Do you know Ira? Pretty sharp guy.
He's actually a real lawyer.
He's a very sharp guy.
Some of these places don't have great lawyers, but he's a good one.
Yeah, and he's got a great resume. And we told him, look, Ira, we don't interfere in litigation. We have in the past done some form of motion to intervene or amicus, and I'm probably misspeaking. It's probably not a motion to intervene. It's probably an amicus, and we've lost. In fact, if you go back in time to about 2008, around that, Sheldon was on the winning side of one of those, and it was the Sheldon versus John Smith litigation. And I think Sheldon was asking for information from the board or something along those lines, and then Chairman Nylander went in to try to fight, but it didn't work. And the judge ruled that the judge could look at the stuff in camera, which was okay at the end of the day, I think, in the big picture. In terms of the type of investigation, it's definitely a separate one. And one of the reasons why it's a separate one is because Sands requested that. Mark Clayton represents Sands, and early on when this started, in fact, I think Lipparelli might have been the chairman, we said we're going to do an investigation into these allegations, which is routine. Anytime there's allegations made by someone against someone else who's a licensee, well, we have a duty to look into it. So we said we're going to look into this stuff.
Why would you guys be investigating something like stepping totally back? Why would you guys even be involved in the CEO claiming they were compensated or not compensated?
It was the claims that there was corruption, and there were a lot of corruption claims regarding Macau. Yeah, in terms of the employment law dispute, we don't care about that. But in terms of foreign gaming, I think Jacobs made some claims. And, we're lawyers. We know that anyone can allege anything in a complaint. But he made some nasty claims, stuff about Macau, stuff about, Addison paying people off, or the company paying people off, or doing things that were inappropriate. And so we started to look into that. But early on, Clayton sent us a letter, and I have the letter, where he said, look, we've created an audit committee, and that audit committee is going to investigate these allegations into the corruption or FCPA issues that Jacobs is alleging. And they did. They formed an audit committee to do that investigation. And he said, Clayton said, back off. If the board can just take a back seat right now, and we will send you those audit papers when the results are in, then you can take that and do with it what you will, or continue your own investigation. And we said, okay, because that's also kind of typical to create an audit committee to look into those things. Okay. And that was done, and that went on. But the feds, the FBI, I think it's DOJ, and forgive me if I have some of my facts wrong, it's been a while, but this has been going on for years. They started their own investigation. They're doing their own thing. Now, what we do is we will communicate with them and say, where are you guys at? What's going on? What do you think? Is there something you find an issue with here? And we have that good relationship with them that is, it's a very good relationship. But we never really worked with them. We never did anything in conjunction with them. What happened is, and where I think I thought Ira had backed off. I don't know who's coming to you on this thing, but
it's Ira's the same 7
push
items or whatever.
Well, I believe it was the audit committee, Adam, began to have some meetings where they invited several agencies that were looking into it to attend these meetings. I don't know the physical location where those meetings were at, but I had my chief, Mike Labadie, of investigations, and he had an agent that was solely dedicated to monitoring this stuff. They just attended by telephone. I saw somewhere in a motion or in an order, somebody alleged that Gaming Control Board agents were in New York 7 times or something. Not true. They never went to New York. They're just sitting on the phone. And what it is the audit committee saying to these agencies who attended the teleconference, here's what we found, here's where we're looking, here's what's going on. Because it's an independent audit committee, and so I think O'Melveny was the firm doing it. And so they attended like 6 or 7 of those meetings.
Okay, so it's the outshot of that process is what is being fought for right now?
I think what's going on is somebody, it must be Jacobs, is making a discovery request of those audit papers, I believe, or audit results or presentations or whatever it is. And I believe Ira's theory is, which is novel and one that we haven't heard, nor has a statute spoken to it or a court, it is when you gave that presentation, audit committee gave that presentation to these 4 agencies, because you gave it to the board also, 463.1 should attach to all.
Yeah.
That's new, in my 18 years.
I understand that.
It's a very smart,
and it's
approach.
not something that our guys anyway think we should support, and it's not something I'm
It would
asking
be
to support.
Yeah, it would.
I mean, we can look at it down the road outside of this context on whether it'll be up to you guys. I mean, is this case going to create a chilling effect for you guys, and you guys have to figure that out? I mean, maybe there will be less cooperation if people think there's an issue, but
That chance exists, and it does concern me. But here, you have the case at the district court level. It's in front of Judge Gonzalez. She's under attack
yeah,
by the Sands people. They've had reporters following her around. We're well aware of all that. I don't want to affect her, interfere with her. My thought and my staff, and I think if you ask Brandon Caton, they would agree. Let the judge make a ruling. Whatever the ruling is, it's going to get appealed. And that ruling in turn could get appealed. If this thing
well,
gets to
except
the
there's
point...
there's no more rule. So where it is now is, she said she was going to review it all in camera, and that was it.
Oh, okay. I haven't heard that.
Okay, so she said she's reviewing it in camera.
Mm-hmm.
And then, since the Sands has appealed, whether she's biased or qualified or whatever that is, so they're unrelated, but they've appealed something else going on with her.
Okay.
That's in the Supreme. The reason I wanted to talk to you today is because that's going from the Supreme Court, the April 5th. Which means they won't rule that day, but they could have a ruling as soon as a week after that. And so let's say odds would be that they keep her. The Supreme Court says we don't see anything here. Of course, Sands thinks it's really strong and they're going to throw her out. But regardless, let's just assume they keep her.
So that appeal to the Supreme Court is to get rid of the judge?
Yeah.
Okay.
To have someone else decide.
Gotcha.
So, assuming she stays, then basically
Making a mess here.
effective the second the Supreme Court rules on that, then it's just back to her. She stayed discovery, which would include the in-camera review until the Supreme Court. So as soon as that's undone, she's going to review it in camera. And so I think that the slight difference from at least where I thought we were, and maybe you thought we were, perhaps that's what Sands thought at the time or told us, and whatever Cable Brin came up with, and they ran it down. I think everyone thought that there was going to be an independent shot to appeal the in-camera review.
Okay.
And there's not. I mean, the judge, these people are gods in that respect. And when it comes to discovery review, and especially in-camera review, there's really no one that's going to tell her no. So the only two parts of this. One, setting absolutely aside 5 or more of the things they're asking for. What I wanted us to talk about is simply the gaming control, Sands privilege, and potentially the Sands gaming control privilege, that narrow lane, leaving everything else off. But she otherwise will reveal. So the question is whether we would do an amicus in advance of, or be prepared to file an amicus once the Supreme Court decides whether or not they're going to throw her out or not. And I think that otherwise there's, as far as I understand, that the judge has actually made notice, not that these judges don't know what have any idea what they're doing, the judge has made notice of the fact that the state hasn't made their opinion known. And that's somehow going to factor in probably negatively. That I think she's under the impression that this is important enough to the Gaming Control Board or the state, they would have weighed in on this thing heavily. Even though, if you're having a one-on-one with her, you'd say, well, no, we've never really had to get involved in this, and we normally would later or whatever. But her impression is, hey, this privilege thing was something that was real, then someone would have jumped in and at least filed a brief. So that's my question. I know you want to stay out of the broader piece. I know we don't I know you don't, and we agree, don't even want to touch this joint investigation, and whether it covers all these other agencies. Sands can battle that out and figure out whether they can convince a judge that it should or shouldn't. But as to the narrow piece, are you willing to support? I mean, the thing could be a 4-page amicus, and it'll be as narrow as you would be comfortable with, simply laying out, here's the law as we see it. Didn't even need to mention the facts of the case. It could be literally that narrow. It is essentially for a judge that that probably has never operated in this space, or if anything, 1 or 2 cases, simply laying out.
She has.
Yeah.
She should be well familiar with gaming law. And, you know, I'd love to sit down with her one-on-one, even like this, and chat with her. But
I'm not sure if you're allowed.
I
No, I think
no.
you can. You're not a party.
I never would, simply because I don't want to interfere with her and what she's doing. She's under a lot of fire. Now, if both parties came to me and said, go ahead and file it, and there wasn't, I think, any beef on the other side in terms of this is the law, you know, we have filed.
Because, by the way, our brief, at least as I see it, would not be totally helpful to Sands. I mean, it'd be hurtful in a number of ways. You know what I mean?
Yeah, I don't know.
Well, in
I
the
don't know
sense
enough
that,
about the
you know,
nuances of the case.
Well, just in the sense that they're making this broader argument that the privilege covers all of this stuff.
Mm-hmm.
To the extent that we weighed in, we'd weigh in and say, the only thing we see the privilege covers is this narrow piece.
Yeah.
You follow me? I mean, it actually makes the rest of the case harder for them, I think.
I wouldn't mind talking to Ira a little more. He hasn't called me about this. You know, those
He's
guys
probably
are
nervous
free to call
you,
me.
that's all. These
Well, I
guys-
like him. I mean, I think of him as a good guy, and
Well, then if it's okay with you, I'll have them. Obviously, the time is
Yeah,
short.
he can-
if you're
he
able
can
to
call
jump
me
on the phone with him
anytime.
early next week, because
well, I'm going to be gone. I'm going to be on roller coasters all week.
yeah.
We're going to Orlando.
Oh,
Yeah.
really? Roller coasters?
6 a.m. tomorrow
I thought you
morning.
meant you got a crazy work.
No,
schedule.
we're going to be going to the first family vacation in over a year.
I'm trying to think.
So we're going to Universal Studios. But the thing, you know, just so you know, my main concern is the state, protecting the statute. I am concerned about the confidence. It's not a privilege in 463-120, it's a confidence, and essentially it says that whatever information a licensee or an applicant prepares, produces, creates, whatever, and gives to the board is confidential. But then there's carve-outs to that, where it says it can be released in the administration of justice and under certain circumstances. So it's a good statute, but it's not 1,000% bulletproof.
Yeah.
My overall concern isn't for one licensee or another, it's just for the entire industry, and the fact that licensees or applicants should be able to produce stuff to us full well knowing that we will never turn it over. And we don't. You know, as you know, we win every motion to quash on subpoenas that are sent to us. Now, whether that document was also sent to someone else, like I said earlier, I don't know if there's been any court rulings on that or any other dispositions.
And I don't
There's no
think
statute.
By the way, I don't think we should argue that. And I'm trying to show you just how narrow that I think we should argue. I mean, you shouldn't argue the fact that it's been shared with another agency. Let them argue that. I don't think we have the law on that, but it would be the question is, anything prepared for the Gaming Control Board that you guys have, for sure, you guys, we'd all fight to the end to protect that. But anything that is, and meaning they couldn't get it from you. But the question is that same, so you reach to the Sands and say, I want you to answer in a 100-page report the following 5 questions. Can the third party that's suing say, I want that 100-page report you made for the Gaming Control Board? And Bryn says, and Caden say that shockingly it's never really been tested.
Not in this field,
which
but
of course would make it.
the overall law
Would
on
kill
the
it.
matter is bad. The overall law is bad, and it started with the Third Circuit, and then I think the Seventh, and the Second, and the Ninth.
Saying you got to show it.
Yeah, and we've been dealing with that issue for about 6 years now. If a company feels that something inappropriate has occurred, they can create an audit committee, or they can create an internal committee. Hire a law firm is the typical way to do it, to do an investigation. And the question is, okay, did Joe Blow do something wrong in our company? They hire a firm, do an investigation. The traditional path was for the company to take that investigation and then go to the SEC or the DOJ on bended knee, essentially, and saying, look, we've uncovered an issue, we're coming to you with open arms, here's our investigation, will you be lenient on us? And for years, it worked well in terms of the SEC or DOJ would say, thank you for the information, and the information was confidential and protected, but there might be a fine or some disciplinary action or what have you. But plaintiffs' lawyers started chipping away at that several years ago, and I think the Ninth Circuit has ruled now on that. And I can't remember the name of the case. I have it was about 3 years ago, that indeed, when you send that information to a federal agency, and this is all in the context of criminal cases, Adam. It's never been tested in a gaming case or a civil case, to my knowledge. It's all criminal action.
Well, and in those cases,
They say-
the privilege isn't made by state statute.
No, and we do have, and see, that's the thing, at the end of the day, I think we've got a good statute. I think we've got a solid statute. If Judge Gonzalez were to chip away at that,
do you agree
we'll fix
that,
it.
that anything made in preparation specifically for a gaming control board request has to be protected both ways? I mean, if not, then no one's going to make anything for you guys.
Well, under the statute, the Nevada statute, 120, anything made and given to us is
You guys protect.
we
What
protect.
about?
But if
can-
that same thing is given to someone else, if it's given to Adam Laxalt
Well, not that.
or whoever,
Well, let's say, forget giving it to someone else. I'm the Sands. I make a 100-page report for you. Third party asks you for it. You're not going to give it. Can they ask the Sands for the 100-page report prepared for you?
well, they can ask.
But
I
agree
think
that
that some of
we
the
would
circuit,
say no.
we would never give it, but I think some of the circuit courts have recently ruled that once you waive that
But
privilege,
do we think the law?
it's waived to
Do
all.
we think the law protects? And then, by the way,
Our state law does. I don't know about the federal law.
As we were, and Ira didn't disagree with me. I'm like, well, just because of the fact that there's 100 items put into this request and sent to the gaming control board, doesn't mean that the third party can't get to this information. I mean, they just can't say, hey, give me that report you prepared for that group. They can still ask a lot of questions to get the exact, I mean, it doesn't actually protect any of the data or the underlying information. They can't just say, hey, give me that thing you produced for somebody else.
Yeah.
They need to ask the questions
Yeah.
that would get to the same question. So if they're asking for, what are the firing procedures, or I still don't have any idea what the underlying case is, by the way. But if it's, I mean, I know
Well-
that's, I know what the big thing is. But I don't know what they're fighting over by way of information. I don't know what was passed to you that apparently is people are trying to hold on to.
well, that's the thing. That's the thing. Nothing was passed to us.
Yeah.
The only thing that was passed to us was, well, I should take that back. I mean, what was passed
Is
to
it
us
the audit report?
was information from the audit committee in terms of their findings, but it, was also, like I said, these teleconferences where the audit committee would update various agencies.
But is that basically what they're asking
including the
for? Is
board.
the audit report?
I think. Well, I don't know. I don't know either. I don't know. We'd have to ask guys like Brandon,
Because again,
my chief of
the
investigations.
guys, if you're the third party, you could still get to all the information in the audit report.
What I can't
You ask
understand-
questions differently.
Help me with this, but why is Sands? Why are they so adamant on this
I don't
and not
know.
giving up? Why are they pushing you right now? Why are they pushing my staff? They did initially, but then I thought they backed off. But they must be talking to you about it.
Yeah, well, they want.
I don't understand what they're.
Well, because they had the hearing. I mean, I think they didn't back off. I mean, they went into the hearing. I guess what's his name, Liparelli,
Yeah,
Got-
his I don't think his stuff was entirely accurate.
Look, I'm not. Believe me, I mean, I understand. I see everything, and I'm not trying to pitch a side or anything on it, but it's simply because they are still fighting and they haven't given it up, and it was just been the timing of
Yeah.
stuff.
Yeah.
The last few weeks, I guess they've been distracted, but
Well, there's some other concerns as well, you know, in addition, and you know, I mean, number one, I'd like to hear if Judge Gonzalez has intimated that, you know,
she's
the
waiting
board
for
must
statement.
not care, or, you know, if they haven't weighed in, they must not care. I mean, if she said on the
Let
record,
me see if that's in the record.
yeah, if she said on the record, hey, I'd love to hear what the Gaming Control Board thinks, well, that's gonna, that would mean something, you
Okay.
know, to me.
Let me check
Because
on that.
we just don't interfere in the litigation. I mean, we just never have. And going back to what I said earlier, in the times that we have tried on this, things like
tough
this,
request,
we've
by the way.
lost.
It's a tough request. That's why I'm having the one-on-one conversation with you. They're asking me, they've asked you, I'm following up with you and seeing where we are on this thing. I think it is it's a challenging request because it will look like that Sands is getting a special thing. And so
Yeah.
I wouldn't do that if I think it jeopardizes me either. And that's why the only way I think it's even possible is if we do think that the narrow privilege is in some way in jeopardy and we kept it that tailored.
Yeah.
That's the first thing I told Ira. I'm like, this got to be crazy. Like, there's no way that we could argue all these things. It wouldn't even pass a laugh test.
Well,
as
the
far
optics
as-
would be horrendous,
Yeah.
and there is other litigation going on. You know, there's hundreds of cases right now that these same lawyers are probably fighting on. The bar would become well aware, you know, of the board and what it did and what it could do in terms of intervening, and so it would be a slippery slope. But I was going to ask you, in terms of the ruling from Gonzalez, if it's not something that can be appealed, it must not be something that can be relied on by another judge in terms of precedent. I mean, there's no precedent created at the district court level, right?
Well, I think that they'd be able
So-
to challenge the evidence. So she did an in-camera review and said, aha, I got the magic bullet, which I don't know that there is a magic bullet, by the way. I haven't asked. I don't want to know if there is. I don't think there is, as far as I can understand, but I think what they'd be, so she did an in-camera review and put some evidence, accepted some evidence. I think they'd be able to challenge, hey, this evidence shouldn't be in here. It got in under the privilege, etc.
Yeah.
But she would have already reviewed it. She would have already gone through it. She would have already seen it. And I guess that's you can't unsee.
I mean, for me, I
Evidence
think if a
review.
district court judge were to make an adverse ruling that I saw chipped away at 463-120 in a very problematic way, and it had some precedential value where
That's-
others could rely on it, that's problematic. Or but I think you want to
wanna
wait until it's on appeal or until it becomes true precedent, say at the Supreme Court level. That's when you start to probably sweat in terms of protecting the statute. Now we have every legislative session considered going in to bolster the statute because the real problem is the federal chipping away of it. But we never have, simply because the statute we've all relied on in terms of being pretty solid if you look at it. Have you looked at it? Take a look at it. I mean, it's a pretty damn clear
No,
statute.
but it reads solid except for the reverse. I mean, forget the joint investigation thing, which I think is potentially an issue too going forward, because everything's joint now. So we got to think about you guys, and we can help. And we got to figure out whether you need that bigger coverage, or whether companies just need that they ask you guys directly to.